I have great respect for the Supreme Court, and I want to just thank them for working so quickly and so diligently and so brilliantly. And again, this is a unifying factor. Everybody now is together, and they can go after me as a politician, they can go after me with votes, but they're not going to go after me with that kind of lawsuit that takes somebody out of a race who's leading in this case, but even if the person wasn't leading. And I want to thank you all for being here.
A huge 9-0 victory, unanimous decision at the U.S. Supreme Court. The ACLJ, representing as a party the Colorado Republican State Committee, won 9-0. The Trump campaign won 9-0. You cannot have states using the 14th Amendment, Section 3, to decide when they want to remove a candidate from either the primary or the general election. Now, it was a per curiam opinion. And, Dad, you talked about what the per curiam opinion was, which was by a decision of the entire court in a unanimous agreement. But I know people are out there thinking, I've even seen on Twitter, is the fact that it's not signed take any power away from it?
No. In fact,
people want to know that.
I think to the contrary, and Andy and I were talking about this before, per curiam means simply through the court. You had the rare situation where all the justices were speaking with one voice. And the one voice that they spoke with is because the Constitution makes Congress, rather than the states responsible for enforcing Section 3 against federal office holders and candidates, we reverse. In other words, the states can't do this. So I think to the contrary, I know some pundits are saying that, but Andy, in reality, the fact that it's per curiam sends a more powerful signal.
Oh, absolutely does. Per curiam, as Jordan said, is a Latin term that means through the court. It's not authored by any particular justice or the Chief Justice, but it's put together by the input of all the justices, and I think it gives it added impetus and added influence and added persuasiveness in that no one justice has spoken, and the court was not divided. It was a unanimous decision per curiam through all the court that the federal officers owe their existence and functions to the united voice of the whole, not a portion of the people. Powers over their election, I'm reading from the opinion, and qualifications must be specifically delegated to rather than reserved by the states. It's not a state power, it's a congressional power.
This was a federalism issue here, and we're going to get into what that means, but I want to make something very clear. To those pundits that were saying the Supreme Court is a political institution or it's falling on party lines, this was unanimous as to what the role of the states were here. And the role of the states in this were nothing. The states cannot seek to remove a candidate, disqualify a candidate from public office for president based on the 14th Amendment, Section 3, which, as we put in our brief, which was really utilized by the court significantly. We're going to go to that in the second half of the broadcast. I'm going to break you down what we said and where it came up. But this idea that the 14th Amendment would be an empowerment to the states, when actually the 14th Amendment, which was done during Reconstruction, Harry, was to limit the states. So the court, all 9 justices, got that part completely right.
Precisely. So states do have power to disqualify, but only with respect to state as opposed to federal offices. And it's clear beyond question that the presidency is a federal office. And so this case raised the question whether the states, in addition to Congress, could enforce Section 3. The Supreme Court answered that question unanimously. The answer is no. It's up to Congress.
It's interesting, Cece, that, and I'm going to go to Justice Barrett, she wrote a concurring opinion as well. And a concurring opinion means the same result, some different rationale, but she made a statement here that I think is very important for people to understand. And this is going to this politicalization issue. All 9 justices agree on the outcome of this case. This is the message Americans should take home. Let me read that again. All 9 justices agree on the outcome of this case. That is the message that Americans should take home.
Yeah, it's very encouraging. I think we were encouraged even when we heard the oral arguments that all the justices seemed very focused on the language of the 14th Amendment And even in the opinion, it says, the 14th Amendment on its face does not give this power to the states. And so they very much followed the Constitution, and we saw that from the left and the right. So I know a lot of people are saying this is political, but I think it's the exact opposite. This is not a political opinion. This is an opinion that actually follows the Constitution.
If you have questions on this and like how this is going to impact the voting, I mean, the Super Tuesday is tomorrow, or what all of this means when you get a 9-0 opinion like this, and then you get these concurrences that maybe they didn't have to go as far as they did, but you know what, this does it settle the issue for the future? We want you to call us. There's no bad questions on this. I mean, these are complicated issues, and obviously you saw the timing it took for the Supreme Court to put together what was a very short opinion. I mean, I was expecting, because they were taking so much time, like hundreds of pages, but it was very tightly worded, very specifically worded. This is one that we'll have it through links at aclj.org. I've tweeted out the link as well. When you have time today, I mean, you can read through it, and it's not like what I was expecting because of the time delay.
Very little on the issue of insurrection.
Almost.
They referenced that was the allegation made in the complaint in Colorado,
Yeah, I think
but that was it. It was the law, which is exactly what we argued in our brief. Now, this is different than the immunity case, which is currently pending. We're working on that brief as well, because there also impacts not getting into becoming president, but operating as president. And these are huge ramifications for our country.
Now we've gotten over the hurdle to actually becoming president. If being
Now
able
you're
to
the
be on the
president.
ballot.
Now you could be sued, you're criminally indicted for decisions you make that are your official acts as president. That's the next challenge.
Yep. John in Boston on line 1. Hey, John.
Hi, good afternoon. Thank you for taking my call. I was just wanted to ask the obvious question, how this affects the judge's decision in Illinois to deny Trump on the ballot there.
President Trump will be on the ballot. Let me play this. This is from Eli Honig on CNN this morning. So, John, you will have him on the ballot, bite 38, and your vote will be counted.
The bottom line here, though, is this is unanimous. It's not up to the states. And another really important point, this is it nationwide. All the 14th Amendment challenges, Maine, Illinois, the dozens of others that had failed or were still pending, it's over. The 14th Amendment will not be applied to Donald Trump. He will be on the ballot in every state where he wins the primary.
So now the question is, we've got these other cases that caller was talking about. We have to go back in on those, file motions to dismiss. You hope these judges don't come up with some creative attempt to try to keep jurisdiction. I don't think that's likely here. But let's talk about the big takeaway here. And I want to get everybody's view on this. I'll start first with Andy. What's the big takeaway? What do you see as the big takeaway here?
The unanimity of the court. That impresses me. I'm looking at the concurring opinion of Justices Sotomayor, Kagan, and Jackson, the three liberal members of the court. And here's what she said. Sotomayor, in writing, said, allowing Colorado to make the decision as to who to keep on the ballot for the presidential election would create a chaotic state-by-state patchwork at odds with our nation's federalism principles.
Yep.
That is enough to resolve this case.
And the chaos, CC, is something we pointed out to in our briefing, both at the petition stage and at the merit stage.
Yeah, absolutely. And again, I'll go to the oral argument because I think that was so telling of this opinion that they focused, the justices focused, and even the liberal justices focused on the chaos, as Andy just pointed out. That you get, a single candidate would be declared ineligible in some states, but not others. And that just would cause complete chaos and actually nullify the votes of millions of people. It could have that effect.
Harry, and the fact that it is unanimous, what's your takeaway on that part?
Well, I think to go back to Andy's point, number one, it removes chaos. Number two, it removes basically instability within the system. It's important to keep in mind that individuals in Texas and West Virginia have proposed either legislation or judicial action to remove President Biden from the ballot on the other side. So what the Supreme Court has done here is that essentially they've eliminated the 14th Amendment as an avenue for removing any candidate from the presidency. That is a step forward with respect to democracy. The Supreme Court opinion defends democracy.
All right, I want to hold up for our ACLJ members, ACLJ champions, people that support the work of the ACLJ. In my hand, for our radio audiences, it is 6 inches thick. This is the paperwork, and it's actually 3 times this because this last volume, which is about an inch thick, there are 4 of. I just can't hold them all. This is what we filed in this case to get this victory. This is the amount of legal work that went in. So we want to encourage you to do something. This is, as we said, a resounding victory for the ACLJ at the Supreme Court, unanimously ruling in our favor, keeping the former president on the ballot. It's one of the biggest Supreme Court victories, frankly, we've ever had, certainly the biggest on election integrity. We represented the Colorado GOP in the case. Of course, we had cases all over the country. We protected your right to vote for the candidate of your choice. The only way we get these victories, though, is with your support. But the legal work does not end. We've got that immunity issue we're fighting now. So once you're in president, can you then be, criminally prosecuted for the official acts you take? The answer has to be no. So we're fighting that. We've got to get dismissed the remaining 3 cases, which we will. And then again, as I said, the immunity case. We must defend the Constitution once again, though, to make sure the president has the full authority to act without having a battery of lawyers for every decision they make. Go to aclj.org and have your tax-deductible gift doubled during our Life and Liberty Drive. If you can make that a monthly gift, by the way, you become an ACLJ champion.